I think it's.
So how'd the other two go, I guess?
That's what I was gonna.
It went well.
Everybody got along?
Well, there may be a disagreement. I'm asked, so Mr. Parker will have a rebuttal, but how do you think the first two types went?
They went well. The parties get along, and I'll tell you what Judge Kishner did with this.
Calling case A 831-169 for Wren versus the Finley Lifestyle Not 28.
Here, go ahead and state your appearances.
Will Kemp for Plaintiffs. Your Honor, Teddy Parker for Plaintiffs.
Good afternoon, Your Honor. Eric Pepperman for Plaintiffs.
Samuel Markwood for Carrier Plaintiffs.
Good afternoon, Your Honor. Joel Odou and Matthew Kaufmann, who's on Zoom for the real water defendants.
Eric Freeman, also for real water defendants.
Your Honor, James Gilroy, Chad Ferry, Christian Ogata from Milwaukee.
Hey, good afternoon.
Good afternoon, Your Honor. Nushan Nuradini, also on behalf of Costco Wholesale Corporation.
Good afternoon.
Good morning, Your Honor. Daniela LaBounty, also on behalf of defendant Costco.
Hey, anybody else on Zoom?
Yes, good afternoon, Your Honor. Suzanne Richmond on behalf of the real water defendants.
Okay. All right, so we had place motion limine 31. Is that correct?
Yes, Your Honor. I believe that was next step.
Okay, so all the same prelims apply. I'm probably inclined, although I have a question mark, so that means I'm not sure, but I'm probably inclined to grant this one as to sleep apnea, stroke, high blood pressure, agent one exposure, but probably be good to hear first from plaintiffs instead of waiting for rebuttals.
Yes, Your Honor. I think plaintiffs obviously agree with your inclination. I think the big problem here is that, well, first, Milwaukee was the only one who opposed the motion. Real Water did not file an opposition here. Real Water's conceded to causation and these related injuries, and that these other medical matters have nothing to do with the injuries alleged related to the liver acute hepatitis and caused by Real Water. All the past medical bills related to these have all been stipulated to. Milwaukee didn't oppose that motion. The real problem with allowing Milwaukee to get into these unrelated medical issues with Mr. Tagano is that they do not have an expert to say to a reasonable degree of medical probability that any of these prior medical conditions are related to Mr. Tagano's acute liver injury. It's all speculation, saying some of the generalized symptoms are associated with, things like medication he was previously taking, and really their argument is they should be able to say, well, these generalized symptoms could also have been caused by this medication or some sleep apnea or high blood pressure, so don't find that they're related to his acute liver injury caused by Real Water. The problem with that is they don't have any expert to say that. It's all just speculation of saying, well, it could have been this, it could have been that. This harkens back to your ruling yesterday, I believe, with respect to the carriers, where generalized symptoms, you got to have the expert to tie them to something, and that's what's missing here. So based on that, we'd ask you grant the motion based on your information.
Oh, thank you very much.
Some of these we did not object to.
Yeah, the strokes
And I will
and
tell
the
you,
apnea.
but as we went through in our opposition. I'm sorry, Your Honor.
Oh, I said this. Oh. So you agreed with the strokes and apnea, right? I think.
Yeah, we definitely do that, but we have the issue with the diabetes and high blood pressure. If they are alleging those as damages and are seeking compensation for those, then I think we were allowed to talk about those. And so kind of give you a step back. In this process, you need to file a plaintiff fact sheet. It's the same thing as interrogatories, it's under oath. There was no mention ever of Agent Orange exposure. It's just not exposure. We found out the day before a rebuttal expert deadline that he had an 80% disability by the Veterans Association, the Veterans Administration. That Agent Orange, which can cause some of these high blood pressure, the diabetes. So if their intent is to seek compensation for diabetes and high blood pressure when we have this Agent Orange disability that's already been determined, then yeah, I think that is fair game to talk about. Also, if he alleged in his plaintiff fact sheet, slurred speech, double vision, fatigue, extreme weakness, and he had just changed his medication that he had for high blood pressure. I think that's fair game to talk about that, saying that that's not the result of the real water and the hydrazine. So yes, there are some things we're not disputing. We don't need to talk about sleep apnea and stroke. And one of the things we talked about is there was some mention to some, how to say this? In the report from the Veteran Administration, there are some ailments that would be embarrassing that we agreed that we would agree to black out, dealing with ED and stuff like that. I mean, we have no inclination going into that area. But if they are seeking, and we do have, and our expert did talk about I can go back, and I apologize, Your Honor.
That's okay.
When I said I tongue in cheek had a headache yesterday, it actually developed into a migraine. So I'm still on the effects of the medication. So I apologize for that if I'm a little slow.
That's okay.
Is that our Dr. Tinner does talk about the neurological aspects about that. And so yeah, we think the high blood pressure, the diabetes, if they are seeking to get damages for that, then they are fair game. And I think that also the Agent Orange is fair game. We listed the citations of Agent Orange and diabetes, Agent Orange and being a liver toxin. So those are issues, when we're talking about damages, I think that they're fair game to go into. So yes, we concede that there's some areas that we don't need to go into. We're also free to redact if the Veterans Administration disability, because there are some personal things that have no relevance, we will redact anything that has that's not high blood pressure, diabetes. We will definitely redact that to make sure there's no embarrassment. So we believe that this should be denied, especially given that these go to damages, and we ask that you do that, Your Honor.
So one of plaintiff's main arguments on these other things, is that there isn't, defendants don't have an expert who, to a reasonable degree of medical certainty, et cetera, links any of these things to, I guess, anything. So does Dr. Tinner say these quote unquote symptoms are caused by something other than the real water? Or
he does talk about the neurological about causing his acute liver failure. So if the question is,
well, I don't think they're seeking to exclude liver failure, at least.
Exactly. What I'm saying is, on acute liver, we're saying if they're saying that they don't, we have a federal document, the Veterans Administration, saying that he has a disability that is causing diabetes and high blood pressure. Okay, if they're seeking damages for that, I think we should be able to bring that in if he already has a diagnosis. If we are not saying his diabetes and his high blood pressure caused his acute liver failure, that's not what we're saying. We're just saying if you're seeking damages for these other ailments, there is a diagnosis already there that he failed to produce. We were able to get it after expert disclosures, and that we should be able to talk about those. If he is seeking compensation on high blood pressure and diabetes.
Thank you very much. The first question is, I forget his name. This particular plaintiff seeking
Ogata.
compensation for his diabetes and high blood pressure in this particular case.
No, Your Honor. In fact, the whole thrust of the motion is to exclude reference to these unrelated medical conditions. What we're trying to prevent from happening is the defendant coming in and saying, oh, none of these injuries that we are seeking compensation for, his experience with the acute hepatitis that he suffered as a result of drinking real water, that wasn't really related to real water. That was related to being exposed to Agent Orange in Vietnam, decades ago, or it's related to sleep apnea. And so don't compensate him for these issues when they have no expert to say that. Our claims are related to his injuries and symptoms related to an acute liver injury caused by real water. Our experts say that. We have the past medical bills and records that relate to it. Those have all been stipulated to. And we're asking that any of these unrelated episodes that have medical issues that have nothing to do with that be excluded as irrelevant and unduly prejudicial.
Thank you very much. So part of it's easy because it's unopposed. So strokes and apnea, Milwaukee agrees that that's excluded. Diabetes and high blood pressure, plaintiff has confirmed. I thought that they would confirm this, but they further confirmed they're not seeking damages vis-a-vis diabetes, high blood pressure, and so they're relevant there, but even to the extent they're relevant, defendant doesn't have anybody tying them in, and similar to the Agent Orange, but this may be one of those where doors can potentially be open at the time of trial, but I'm granting the motion for the reasons stated that I've stated plaintiffs put. And so to the extent defendant does think a door may be opened at the time, don't unilaterally decide that it was, approach me outside the presence of the jury and we'll deal with that. So granted 32. This one's unopposed, right? So 32 granted as unopposed. We jumped to 34.
Yes, Your Honor, I think 33 was.
Just making sure. Okay, so 34 plaintiff's motion limiting number 34 to pre-admit real water customer complaints. Inclined to deny without prejudice. Foundation I think would need to be laid at the time of trial. Cases, there aren't really any cases directly on point that support plaintiff's position. So I'm not inclined to grant, blanket pretrial admission or pre-admission admission. Of course, that's without prejudice. It's the proper foundation during actual testimony, but welcome arguments to counsel.
I don't feel so welcome, John.
Well, I
felt welcome when I first walked in.
No, you're still welcome.
Good afternoon again, Your Honor. Teddy Parker on behalf of the plaintiffs. Your Honor, I spent a lot of time preparing for this motion this morning and last night. And I thought there would be some robust discussion about what complaints would be allowed in. Not that they would not be, that the motion would be denied, without prejudice, which I appreciate, Your Honor. But there are decades worth of Nevada case law on the subject. Perhaps, and I understand what the court's point in terms of being, on all fours. But certainly the case law from Beatty Thomas to Guinness versus Mates all talk about the use of prior and subsequent complaints in support of causation, notice, as well as determinative of a product being defective or dangerous. And so,
So let me pause it, because I think we might be a little ships in the night maybe, but so the motion's pretty specific in terms of, you're asking that I pre-admit this stuff before testimony foundation laid. And that's, that's much more of a at least in my view, a discretionary thing. And there's, like I think I mentioned yesterday, I am very much amenable to pre-admitting exhibits that I am, almost 100% certain are going to be admitted. On the flip side, if there is some legitimate question, whether it will be or not, I'm probably not inclined to pre-admit. But what I'm not saying, though, to be clear, is I'm not precluding, their admission during trial. And I understand the arguments that you all are making in terms of prior instances, et cetera, being relevant, admissible, et cetera. But this is focused on more, I would say, I guess, the issue, at least right now, more on pre-admission.
okay, that helps, Your Honor. So you're not, the court's inclination at this point is truly at pre-admitting as opposed to coming in during trial.
Correct.
Yeah. Understood. That helps a lot. Let me say that. The record requirement that I had when I first walked up has been reduced, I would say. Your Honor, the only other thing I would point out, given where the court's going with this, is if you look at page 13 of our motion.
Oh, I'm right there.
Oh, perfect. So, and I only bring this up because of the foundational point that the court made. Certainly because all of these customer complaints are business records, the foundation is already presumed as a business record. And I don't believe Real Water is contesting that these are business records. So I think that they come in because they are business records without any additional foundation being required under NRS 51.135. So I would ask the court to consider that and perhaps have counsel address that issue, because I'm with the court now that I understand the pre-admission part of it. But I would like the court to consider that under 51.135, simply under our evidence rules, it comes in as a business record and no one's contesting that it's a business record. And if you were to look at page 3, Your Honor, we speak, there's a customer complaint that deals with Mr. Watkins. This is roughly at line 19 on page 3. I'm just using him as an example.
Bear with me. Okay, yeah.
And so he was hospitalized with acute liver failure. And his wife sent an email on June 20th, 2018 to Real Water, informing Real Water that Mr. Watkins had been diagnosed with acute liver failure within the hospital and that the doctor was tying it to his water consumption. And so, Your Honor, certainly this is one where we have Mr. Watkins has actually appeared as a witness in the trial. And we have deposition testimony, we have the emails, we have this as a business record. Certainly 100% of the time, this type of document with that type of foundational support would come in at trial. So I understand the court's concern, and I know this was at the end of our motion, Your Honor. So it didn't start out talking about it, but I would ask the court just to consider the importance of the business record evidentiary statute and why this comes in, because the foundation has already been laid.
Well, thank you very much.
Thank you, Your Honor.
Good afternoon, Your Honor. Joel Odou on behalf of the real water defendants. I think the court got it exactly right on the inclination, and you know, this is our third time through on this, and so we've presented our arguments 3 times. This will be the third time on this particular issue. I think it's
So how'd the other two go, I guess?
That's what I was gonna.
It went well.
Well, there may be a disagreement. I'm asked, so Mr. Parker will have a rebuttal, but how do you think the first 2 types went?
You know, they went well. The parties get along, and I'll tell you what Judge Kishner did with this, because I think it was a good way to go. And not just because she ruled the same way as your inclination, but basically Judge Kishner said, and I think the court has said in its inclination, that we should take these on a case-by-case basis as they come up. And certainly in looking at the 28 different or complaints that the plaintiffs are seeking to admit on page 3, very few of those are business records. And so the problem becomes when we try to lump in all of the, and our trial presenter has put them up for the court on the screen, but when we try to lump these all together, it just becomes kind of lost in the shuffle. There's some motions coming up about lay witnesses offering medical testimony. There's hearsay objections. There's a bunch of objections coming up, and the best way and the most efficient way to deal with these would be to address them as they come up or as they're presented in motions. Mr. Parker said that Mr. Fisher's email is a business, or wife's email is a business record.
Watkins, I think, is the one he mentioned.
Or Watkins, I'm sorry, I
That's-
confuse Fisher and Watkins all the time. I don't know why that doesn't stick in my brain. But he argues that the email is a business record. That's not the end of the examinations. I'm sure the court's aware. There's prejudicial effect to that email. It's deceptive. It doesn't say what plaintiffs claim it says. And once we get to the specific objection on that email, I think that's the best time to take it up. Particularly, it says that he was told not to drink alkaline water. He was not told not to drink real water. And so again, whether or not the court's going to admit that when it comes up for evidence, we don't know. And we think it's better to defer that to the appropriate time. I certainly have comments about the case law. I think it's best, again, that we address those at the appropriate time and when they come before the court rather than do it now. But certainly we could talk about all 28 of these. We've done it twice already. We could do it a third time now, but I don't think that's a good use of the court's time. And I think the court's got it right. Let's just take them as they come. And we would urge the court to stick with its inclination.
Thank you. Anything further from it?
Just briefly, Your Honor, Ogata on behalf of Milwaukee. That I won't belabor the point, but I think that the court's inclination is right. You know, a business record exception doesn't permit anything that is at all goes to a business. As Mr. Odou has said, you know, the additional statements, there's multiple levels of hearsay here. So when looking at pre-admission, you have to look at not only whether it's a, you know, kept by the business, but whether the statement that's from another person that is not part of the business satisfies a hearsay exception, which it's plaintiff's burden to do when they're seeking pre-admission if they haven't done. The other thing I think that is important here is the context of why they would like these pre-admitted. As you've just heard, it's for causation and notice. But I think that we're sort of missing the broader picture of yesterday's ruling on where we're at on causation. So certainly these wouldn't go to these plaintiffs' medical causation, or they wouldn't go to their damages. It would only seek to inflame the jury, which is why the context is necessary, because it becomes even more prejudicial. Because, you know.
So let me ask you, because you reminded me of a thought I had when there's several of these briefs where plaintiffs go through this what I would call, well, I don't know what I call it, like prehistory, I guess, maybe prehistory being the particular plaintiffs in my case. So, and maybe nobody really addressed this, maybe somebody did, but you know, there are claims for punitive damages. And you know, something like notice to, for example, in this particular case, real water, I think vis-a-vis what we're dealing with in this particular motion. How, because part of your arguments, like, it's not relevant at this stage. Well, how is it not relevant if there are punitive damages being asserted?
Well, it's certainly not relevant to Milwaukee. If Real Water received complaints, Milwaukee would have not had notice. So it was-
I probably should ask your colleague that
and
question.
that's a totally fair issue, and I think that that's sort of you know, perhaps why we had brought the motions initially to sever these cases, because they're two wholly distinct product liability disputes with different chains of distribution. Milwaukee wouldn't have had notice of these Real Water complaints, so to the extent they're relevant to punitive damages, I think that the question, or to the extent they're relevant to punitive damages, I think that they are that exemplifies that they are more unduly prejudicial. And under that rule, even if evidence is relevant, if it's substantially outweighed by the risk of unfair prejudice, which I think is exactly what happens here, and also confusion of the issues, the jury may consider, well, these other people were sick, so it makes more sense that these people are sick, or it makes more sense for the medical causation for these plaintiffs here. And I think that mixing is precisely what the rule against unfair prejudice is intended to protect against.
Thank you very much. Before you're done, right?
Oh, yeah.
Okay, thanks. Let's bring Real Water back up. And so that question, maybe I should ask you first in terms of if you're arguing that these are irrelevant. If you're not arguing they're, you know, irrelevant, just let me know. But if you are, at least in part, we do have a punitive damages claim. How would they not be relevant to that?
That's right, Your Honor. And we have argued that particular issue before as well. And again, under the Guinness case, the Rheingold case, the Andrews versus Harley Davidson case, those talk about notice in specific instances. In the Guinness case, we have a revolving door injury. In the Rheingold case, we have a slip and fall injury at a water park. Andrews, we have injury from a motorcycle. All of those prior notice cases are readily apparent. When somebody is injured by a door, a motorcycle, or you know, a slip and fall, it's readily apparent the mechanism that caused the injury, and that's the distinction here. When somebody has an upset stomach, when somebody has non-specific injuries that require a medical diagnosis, to say that that's notice to Real Water. So we can use Mr. Fisher, who I keep messing up. Mr. Fisher.
Oh, Watkins.
Well, I was going to use Mr. Fisher, actually.
Well, you could use him.
So Mr. Fisher had consumed a large amount of water and actually got water intoxication. And he had drank so much water in a short period of time that it made him ill. And later it was suggested to him, well, Real Water must have made you ill. And the problem with saying, oh, well, Real Water's on notice is because there's no medical diagnosis there saying that that's what causes injury. When we look at the 28 different things that they would like to offer for notice, first one, they start with John Marlowe. Okay, John Marlowe will likely testify that he was working on the recipe and it made
Is
him
Mr.
sick.
Marlowe the founder guy?
He's the inventor.
Yeah. Okay.
He's a very charming man.
First time I learned about him was actually yesterday when I reviewed that particular motion.
Yeah, so John Marlowe is the inventor of Real Water. He is in his 80s. Certainly, he's been called to testify in the prior cases. We're going to need the court's assistance, possibly because Mr. Marlowe, he is going to answer the questions the way he wants to answer them. And sometimes strays over motions in limine that have been granted.
You all may learn, that I am not a fan of people who do that, but.
Yeah, Mr. Marlowe, I think I can speak for everyone, can't be controlled very well. And so we will all do our best to instruct. Last time we gave him a list of things that he's not supposed to talk about, and that seemed to have worked, but I digress.
Okay.
But then we start looking at, some of these non-specific complaints that were investigated, by the way. I mean, if we look at Ida Watkins or Derek Steffens or Molly with the oily substance in the water, strong chemical smell, gasoline-like substance, plaintiffs would like you to believe that those weren't investigated. And this is the problem with lumping these all together. They were investigated. In several cases, Real Water went to the Terrible Herbs to get another bottle to find out if other bottles were contaminated with anything that was being complained about. And that investigation was actually done and nothing was found. And so that's why if we lump them all together and we start, taking them all at once and saying it all goes to notice, it becomes a problem, Your Honor. We have Lois Kessler, who is, complaining about a very bitter taste. Is that notice of hydrazine in the water? Well, we don't think so because of her testimony, again, is, there was a bitter taste. There's no testing. There was nothing done with that bottle of water, say.
I'll tell you, I'm guessing what plaintiffs will say. I mean, given that I'd rather have you address it, now than just have them say it and you not have an opportunity. I think part of their argument is, hey, there's all these different notices of not necessarily hydrazine, but to speak broadly, perhaps issues with the manufacturing process or something to that effect. So how would that, if that is indeed their argument, how is that not? Because I think you're arguing, well, the bitter taste that is irrelevant. Well, is it really if it's a manufacturing type of defect issue? Or?
Yes, Your Honor, it is, because it goes back to there was an investigation done and they believed it was from the blow mold, not hydrazine. So again, if we take these all together, it becomes problematic. We've got to look at them individually and go one by one and say, okay, what was wrong with it? Was it the blow mold? Was there something wrong with? And the other problem we have, and I'll be very candid about this, there were different real water protection facilities at different times. And so if we are looking at a 2014 complaint, that water was likely manufactured at a facility at Desert Inn. The plaintiffs in this case are 2020 plaintiffs, now that the Caveys are not part of this case. That water was either manufactured at Desert Inn or it was manufactured at Henderson, depending on whether it's 5-gallon home delivery and depending on when. And so I think it is important when we're going to notice to talk about what is the complaint? When was it? Was it investigated? Was there some indication that it was something that was wrong with the manufacturing process in terms of the ingredients as opposed to in terms of the bottling? There was another motion about excluding bottle caps, and that motion was by Costco and it's no longer relevant, but there was a bottle capping problem both for the retail and the 5-gallon line. Again, this is not a case that the injury was caused by bottle cap manufacturer. That's irrelevant. That doesn't go to notice. And so the problem becomes, again, treating these all the same when they're not. And again,
so you've well addressed all those.
Thank you, Your Honor. I just think it's better to take these one at a time.
Your Honor, you asked some really good questions.
Thank you.
Gave me more hope. Felt more welcome.
Oh.
Not that
I
it's
mean,
deserved
just
at
if
this
I
point.
rule against you on one thing doesn't mean you're not welcome.
No, that's true. That's true. Shane, can you put up on the screen, please, exhibit 1 to our motion? And Your Honor, I want to address 51-135 first, because I like the question you asked. You started with, the question came up during Milwaukee's presentation, but it was more suited, of course, for real water. And looking at the screen, Your Honor, if I could, can I approach the screen?
Sure.
Only because.
I mean, I can't look over there. I can see it.
Yes, as long as I'm over here, you okay? I don't know.
I mean, if you want to be over there.
It's easier for me over there.
Okay.
And so, go to the bottom of this screen, all the way to the bottom, make it a little small, there we go. You'll notice, Your Honor, this is a real water date stamp on it. Every document that we're talking about will bear that same, not the same number, of course, but the same real water designation in the front of it. Every one of these documents came from real water. They are real water business records, number one.
So let me chime in there, because so here's what I was gonna say on the business records, and you're welcome to address it, but you know, kind of as you rightfully pointed out in the motion, you know, is kind of your last argument, not super fleshed out, and so then I was just glancing through the reply. It's not really fleshed out there either. At least it didn't appear to me, and so one question I had, you know, in terms of business records, like is you know, I could see that one because the person who signed it, that is a real water employee, right? On that one.
Go all the way to the top again? Yes.
Service, yeah. But for example, you did mention, you know, emails from, or an email from an individual to real water. As I sit here, I don't know for sure if that is or is not a quote unquote business record under 51.135. It may very well be, but I don't know that you really developed that argument.
That's a good point, Your Honor. What I will tell you, and I can do this vis-a-vis the screen here, the emails that we're talking about here actually have a response on a real water business document. So the email is tied to a response on a real water document that has a real water at the top of it. So go to, let's stay right there, Shane, please. So obviously, Your Honor, this document has real water at the top of it. It's on their stationery. Customer alert form. Okay, make it a little smaller. This one talks about Costco and has a real water employee at the bottom. And certainly there can be no objection that this is not a real water business document. Go to, and while we're here, it talks about the taste of the water. First line says water had a bitter aftertaste for the case she purchased. So you asked Mr. Odou, and I think your follow-up question was very insightful. Well, not even a question, it was a statement, because you predicted what I would come back and say, or someone on behalf of the plaintiffs would say. If there's a difference in the taste, if there's a difference in terms of oil, if there's a difference in terms of chemical, all of those things indicate something's going on that should be investigated. Now, Mr. Odou, he is very good at what he does, and he pointed out to Judge Williams. Judge Williams allowed the customer complaints in. Judge Kishner allowed several of them, not all of them, but several of them. And I agree with Mr. Odou. This is not a bottle capping case. But like you said, if there's something going on, it's certainly a manufacturing issue. Figure it out. This certainly provided notice that something's going on. Each one of these issues, each one of these customer complaints identified here came from real water, and in most cases, I believe all in terms of here, but in at least most, if it's an email that was responded to with a customer form or some recognizable real water form. So I don't want you to be misled that the email stands alone by itself. There's a corresponding real water response to it. And that's what we believe should come in as customer complaints. Now, one thing that we did that I thought was effective with Judge Kishner is we went through these one by one, but we did it in advance and discussed which ones should come in. And so Your Honor, I believe these are related to some issue with the water itself, not with the bottling practice. Now, there's a couple, and I know if Mr. Odou had a chance to get up, he'll say, well, Teddy, wait a second. There's one here talking about styrofoam. Now, perhaps styrofoam isn't related. I will concede that for purposes of Mr. Odou, that you're welcome. You would get me on it, so I might as well give it to you.
See, you should feel welcome now.
That's right, I do, I
Oh,
do.
good.
And so I don't want to suggest that a styrofoam issue is necessarily a hydrazine issue. But Your Honor, none of these drinkers of water knew that hydrazine was in their water. In fact, they didn't know what hydrazine was, I would venture to say. We had to find, and I give this to Mr. Kemp, he had to look into the nooks and crannies of chemists to find someone who knew something about hydrazine. There's not a lot of people that specialize in hydrazine. And so for us to expect, or for any court to expect, that a customer complaint will include the words hydrazine in the analysis.
I don't think they're arguing that.
Thank you, Your Honor. So could you go to page 18 of our brief? It's still among exhibit 1. That's page 3. You go to 18. Your Honor, this one is May 21st, 2014. And it actually, it's on a real water. Go up to the top again. Real water document.
Form, yeah.
Form. And it's, the first line says, customer says she found a gasoline-like substance. Our experts have already indicated that when you have sufficient enough hydrazine, it has and will take on that smell. A fishy smell, a chemical smell, a gasoline smell. Several of these actually mention that. If you were to go to page 3 of our motion, Your Honor, you probably remember this now. It says strong chemical smell, gasoline-like smell. You saw it repeated. And then you see the reaction of the customers drinking this water and what it has done to them. If you could go to page 20 and 21 for me. Shane. Again, another real water, go to the top, Shane. Thank you. A real water document. May 6th, 2014. Purchased in Las Vegas at a Chevron. Strong chemical smell. Right below. Now, I also want to address, Your Honor, the relevance of this, because you brought that up during a conversation with Mr. Odou. Certainly it can't be argued that these aren't relevant. So it's a business record that is relevant. So by under 51.135, this would be admissible. And I think would be appropriate for a pre-admission because we know it should come in. It's their document. It is relevant. There's no unduly prejudicial point that can be made on this. Go to the next page, please, Shane. Again, another real water document, Your Honor. Ms. Kyla Watkins.
No, yeah, you're making the same points.
Oh, and I'm just saying that these things are tied. A lot of these documents are tied to emails. I'm going to show you one that actually references.
Oh, gotcha.
If you'd like. Go to 29, I believe. Shane. Here we go. So this is an email to Real Water at the designated location, John. October 21, 2013. And go to the very next page, Shane. And I believe this is their response to the email. So my point being that Real Water responded to a lot of these emails. And what we are pointing out would demonstrate that there's a relationship between Real Water and the email. They received it, they responded to. It's all within their business records. And so I understand the styrofoam one. That's probably not relevant for purposes of this case. And I understand that Real Water is conceded liability. So we're not trying to show that it was just effective. We're trying to show that they were on notice. And for purposes of NRS 42-005, their blatant disregard to that notice, their failure to test for toxins. That all goes to what we're trying to prove in this case, Sean.
Thank you.
Thank you so much, Sean.
So I'm gonna stick with my initial inclination, and I think I was clear, but to be more clear, or at least try to be. So denying without prejudice, and what I'm focused on is what the motion's requesting me to do, which is pre-admit the various exhibits, which I'm not inclined to do. That does not preclude in any way plaintiffs seeking to admit them in the normal course during the trial. Some and put these in the order issues that I let me put it this way to be clear. I'm going to order ORDER, order the attorneys to meet and confer as part of your, pre-trial meet and confer process to consider the exhibits and whether they can be stipulated, these particular ones, whether any of them can be stipulated to admit or not, and things that both sides are to take into consideration include, but are not limited to the following. NRS 51.135, that's the business records. The I don't know how you pronounce it, Benedetti. Bendetti, wow.
Benedetti.
However you pronounce it, that case seems to be pretty close to on point on a key issue. Consider the fact that there is punitive damages claim. Notice is very much at issue for that in particular. I don't know that I really buy the distinction of readily apparent versus not. Some of these exhibits seem to be when lay people are notifying real water that there's an issue, that's probably readily apparent because they're lay people noticing these particular issues. This one thing that I forgot to mention yesterday on one of the rulings, but things can be admitted for limited purposes, and jury instructions can be given to let the jurors know, hey, yeah, this is admitted for a limited purpose. I as a judge can say that at the time admission sought and or in jury instructions. So there's one thing to consider as well. And jurors are presumed to follow instructions. This does remind me, I may have said this yesterday too, but some of defendants' issues with these pre-admission motions are much more a weight type of arguments versus admission type of arguments. And so, take that into consideration. Having said all that, I'm not going to blanket pre-admit them at this time. Again, that's without prejudice. Put all those details in that order.
Absolutely.
Thank you. 35. Plaintiff's motion limited to exclude Dr. Babcock's speculative opinion regarding real water's mixing process. I'm inclined to deny without prejudice, as I think the issues go to weight more than a blanket preclusion and subject, cross-examination, impeachment. but welcome arguments.
Your Honor, I think just briefly on this one, I don't know that Dr. Babcock's opinion is relevant any longer, given the ruling on the issue preclusion. So I can't imagine that he would be called at this trial, and if he is, why or how he would give this opinion. I understand the court's ruling. I just don't want it to be construed as some sort of authorization for Milwaukee to call him and start putting on a causation defense in light
And
of
if they have something different, you'll have a rebuttal. So.
Thank you.
'Cause, yeah, I need to remind myself to ask, you know, which ones are still in play versus not as we get to them. So,
Sure.
Mr. Odou, go ahead.
Joel Odou on behalf of the real water defendants. We'd actually joined plaintiff's motion and would join in the arguments. We don't believe that Dr. Babcock should be allowed to testify now, given the court's prior rulings, and that this is more than goes to weight. This goes to their attempt to argue in violation of Nevada law that there's some type of comparative fault in the strict liability. And so
Is this one that, okay, sorry.
that's coming up later.
Okay,
But that is why we joined.
okay.
Your Honor, I think you should stick with your ruling
Yeah.
and to the extent. And I'll be honest, whether we call him or not, I do not know.
Okay,
And I understand your prior rulings, but that really now this is just a motion that was talking about the mixing. Your inclination is to deny that goes to weight. Now it seems to spread, he should be totally excluded from trial because of a prior ruling. And I would request that we address that at trial to the extent we even do call him. And I think that's the fair thing to do. And whether there could be reasons because of the punitive damages stage why we call him. And as I said before, we're still reviewing, given the consequences of your order, and we defer some stuff to tomorrow. But as to this very limited area, his opinion is based on the science, his observation, that stuff. And it is correct that you to deny it as the call of the motion. Whether he's allowed to testify because of your prior rulings, I think you need to reserve that until we get to trial.
thank you. Any rebuttal?
We're not asking you to rule and exclude him. We're asking to exclude this particular opinion in light of the ruling on the motion for partial summary judgment. There is no situation in which Dr. Babcock's mixing opinion, which completely goes to causation, which has already been established on summary judgment, is appropriate for this trial. And we do not believe that it is workable to just defer on this particular issue, the narrow issue before the court, because plaintiffs are entitled to know what is going to be presented at trial prior to the opening statements and presentation. And if Milwaukee intends to put on this opinion for some reason in light of the ruling on the issue preclusion, I think they should have to articulate that reason to you now, so we're not ambushed by it at the time of trial.
Thank you very much. So I'm going to call it deferred. You know, if indeed, as I suspect is the case, that this type of opinions precluded from my summary judgment or partial summary judgment ruling, then, you know, no need to get into the weeds of the weight versus that. And it, you know, like I mentioned yesterday, you know, I made a substantial ruling, and I think it is fair, appropriate, etc., to permit folks on the defense side of things to weigh and evaluate and see how they're going to respond to that. So court defers motion limiting number 5 or 35, sorry. And let's address it at when's your follow-up calendar call again?
First.
whenever it is, let's address it at that time.
Okay.
And meet and confer in the meantime on this among many other issues. Oh, are we done with plaintiffs?
Yes, Your Honor, that's the last
Okay.
plaintiff.
I just saw different colored binders. Okay. Next up, I think, but correct me if I'm wrong. Well, I have a number of Nevada beverages motions that, were joined. Which I did prepare for because I wasn't sure. That they're all not going to be addressed, given that they have joiners. Anybody want to address the Nevada beverage motions? I am prepared to do that, certainly. And what I have up in my hand at least is their number 10 to exclude Blaine Jones.
Your Honor, Joel Odou for the Real Water Defendants. We're prepared to address the Nevada beverage motions. I don't have anything on number 10, but I do on some of the others.
Okay, okay. You have number 10?
I do.
All right, come on up. So let me tell you, I am inclined to deny it. And basically for reasons, raised in opposition, but, welcome arguments.
As a matter of housekeeping really quick, the list we got today for the Nevada beverage ones were Nevada beverage 1, 2, 10, and 12. Milwaukee joined 10 and 12, but did not join 1 and 2. So
Okay, so let's do 10 and then we'll do 12.
Your Honor, as we discussed yesterday, this individual is a plaintiff in other litigation. So certainly his status as a plaintiff, goes to his bias and motive, which has already been dealt with. But the evidence of his injuries and what he thinks caused his injuries is certainly not relevant to these plaintiffs. As I talked about a little bit earlier, the context here post yesterday's ruling on issue preclusion is certainly important here. This individual is a lay witness. He's not an expert on what medical causation. So it's not relevant. His testimony about his injuries and what he thinks caused his injuries and his sort of speculation about what he would or would not go through for a certain amount of money certainly is not relevant to these individual plaintiffs' ability to prove their damages in this case, nor is it relevant to Milwaukee's to punitive damages for Milwaukee. The other issue is it doesn't help the jury in this context. As this court pointed out yesterday, several people drank real water and didn't get sick. So that's why expert testimony is necessary on these things. This person is a lay witness. And so him adding to the sort of, adding fuel to the fire here is not necessary, nor is it relevant. There's, little to no probative value of that speculation because he's a separate individual about separate purported injuries that haven't been tested or backed by an expert, which is substantially outweighed by the risk of confusion of the issues and misleading the jury.
Thank you very much. Anybody else on the defense side?
No, thank you.
Okay,
I'm doing 10 and 12 and I'm gonna give up on 12 before I forget. So,
okay,
so
so
we can do that when.
12 vacated?
No, it's not vacated, but I want to explain on the record what we're doing.
Okay,
But
so
let's
let's
go
stick
back
with
to 10.
10. Okay.
Okay, so 10, Blaine Jones is one of, he's executive vice president of Real Water. He took a 5-gallon jug with him up on a hunting trip to Utah, drank it, got deathly ill. His father, the president of Real Water, had to go up and get him. They brought him back here to a Vegas hospital. He was hospitalized for, I believe, at least 2 weeks with severe case of acute liver failure. They were going to fly him down to one of the LA hospitals for liver transplant, but he started improving at the last minute. Okay, the reason we think that this is critical relevance is because this goes to what I call the fourth punitive prong. We are arguing that they didn't timely institute a recall. The testimony will be that Anthony Randolph, and he testified at the last trial, this is what he said there. The testimony would be that Anthony.
Who's Anthony?
He used to be the vice president of sales, and then in October when all this occurred, he was a sales consultant or something. He was still working on sales, but he wasn't the vice president of sales. So he's one of the key players in the real water story. So anyway, Randolph will testify that he went into Mr. Jones's office at Real Water and said, well, I know one or two people that got sick. And, you know, we're here, customers are complaining, we're having to go out. And this was in early October, mid-October of 2020. Says, we have to do a recall. And he says, you even got sick, Blaine, you got sick. And so the decision is made not to do a recall. A week goes by, Randolph goes back in and he has a second conversation with Mr. Jones. And he tells Jones, once again, I know two more cases of people who got sick. You got sick. We have to do a recall. So this is part of the recall story. And that's the primary relevance of Blaine Jones's illness. With regards to the statement that there's no, you know, this is just a lay witness thing. This is one of the 25 outbreak cases identified by the Southern Nevada Health District as being probable cases. The five babies are too, but this is one of the 25, Mr. Jones. So the Southern Nevada Health District investigated this case and they determined it's a probable case. And they told Mr. Jones that. We cite that in the opposition. He had a conversation with the Southern Nevada Health District. They call him up and they say, you're probable case. So that is the relevance, Your Honor. And that's why I think it comes in. With regards to the valuation, he went through the exact same injury that all the other plaintiffs went through. He was, you know, I wouldn't put him as the worst case. I think some of the baby cases were worse, but he was a pretty bad case. You know, he was pretty sick. And so his valuation on what the claim's worth was $10 million. He is a vice president of Real Water, managing speaking agent. So that's why that valuation should come in. I don't think it's binding on the company. You know, you don't have to, I can't argue with the court, we should get a summary judgment for $10 million. But surely this guy who went through the exact same injury that everyone else did, his suggestion as to the value of the claim is relevant. And so for that reason, we think this motion should be denied.
Thank you very much. Any rebuttal?
I'll be brief here. You heard that this goes to punitives and that this goes to whether this should have been recalled sooner. Again, these are, that simply cannot be a question for whether Milwaukee acted with a sufficient level of culpability to justify punitive damages. As you've heard from us multiple times, Milwaukee was not involved in the manufacturing. It was involved in the sale of meters. And the fact that, Mr. Randolph has comments about this, or that, Mr. Jones was an outbreak case, that doesn't make him an expert on these issues. He's still a late witness at the end of the day saying this caused my injury, or speculating that caused his injury. The worst part about his valuation is, here's how I personally feel what my injuries were worth. Well, all of these individual plaintiffs here can testify about their own particular damages and amounts. He's not one of the plaintiffs in this case, in this particular trial. So adding him to say, yeah, well, what he said, that makes sense for all of these people too, plus whatever they've told you, I think is particularly problematic when it comes to Milwaukee. So.
Well, thank you very much. So I'm going to deny Nevada Beverages motion and the joinders. So this is Nevada Beverages motion number 10 to exclude Blaine Jones injuries and valuation, and Milwaukee's joinder there too. For reasons set forth in the opposition, as well as an argument, including but not limited to Mr. Jones's position with Real Water, his particular injury, his, unlike, for example, the carrier plaintiffs, his injuries specific, caused arguably caused hospitalization, one of the cases identified by the Southern Nevada Health District. And it is certainly relevant as plaintiffs argued as well. So denied for all those reasons. Let's do 12.
Your Honor, well, we're moving on to the next one, because that one's a little bit odd since the party who filed it is not here. Who prepares the order on?
Oh, that's a good question. Let's have plaintiffs do that one. I had not even thought of that, so thank you. 12, tank fams, fluid tank fams, testimony regarding his neighbors. Still in play, so I'll maybe.
Your Honor, it's not in play because I could take it out of play. Tom Pham, it's Tom Pham. It's not, maybe it's Tom Pham, but he's known as Tom Pham. Tom
okay.
Pham was hired by Real Water to be their quality assurance director. And Tom Pham recommended that his two neighbors purchase Real Water. They just referred to them the neighbors here. The neighbors are named Chip Cuvay, Cubay, and his wife. So they went to Whole Foods, they bought Real Water, they drank it. And then Tom Pham testifies he personally saw it on their kitchen table because he was dog sitting for them. And then the following week, they're both hauled away into the ambulance with acute liver failure to one of the hospitals. So the reason we wanted to admit that this incident is that it was common exposure evidence for retail bottles. Okay, but we don't have the Cuvay case here anymore, and that's why we don't need to offer this evidence. And so for that reason, we're just, what we did in the first case, we played that portion of his video. Pham lives here in Nevada, but for some reason or another, my process server can never get a hold of him.
Okay.
So I anticipate we're probably gonna play his testimony by video again, because we've done it twice in a row. But we will agree not to put that portion of the video in about this incident with his neighbors and Chip Cuvay.
Joel Odou on behalf of Real Water, we think plaintiff and will agree to that. Mr. Pham has a house here and he has a house in the Bay Area, and he flew here for one of the trials and then has been unreachable for the other. So I don't think he lives full time at the house here, just for the court's information. That's why he may be unavailable. And
Yeah, I'm not suggesting he's
No, that's
actually does service, but he does seem to be.
hard to get a hold of him.
It's not as easy to get a hold of as Mr. Marvel, for example.
yeah, Mr. Pham was eager to come for the first one. I think we must have bored him or something.
Can you blame a guy?
We can
But-
prepare the order on that one.
Yeah, so I call it granted in part based on, plaintiff's agreement to not play the subject testimony. Okay. So the bad news on 1 and 2. The bad beverage, we didn't get binders for some reason. So I have not prepared on 1 and 2.
I don't know if those are still in play.
Somebody said they,
I believe Real Water joined them, but I don't think they need to be heard, because we were not gonna, we've heard the court's ruling on pre-admission, and this is not the type of thing we're gonna need to be pre-admitted,
Okay.
so.
okay, so let's call 1 and 2 joinders withdrawn, I guess.
Yeah, withdrawn is fine, Your Honor.
Okay. So next, maybe I have, at least, what used to be Hannah's motion on, number 6, exclude argument or evidence past pending verdicts, lawsuit settlements or claimants. Which was also joined,
That's mine. Yeah, that's mine.
Your Honor, there seems to be a couple, both Real Water and Milwaukee have essentially the same motion about the spikes and the outbreaks and all that. If you want to hear them together.
which one's the?
I'll let Mr. Odou speak for what numbers are the ones that deal with it.
I think we tried to get this and we.
They are listed for today, Your Honor, if we're doing
Yeah.
I think we're looking for the settlement one.
Yeah, that's Real Water 3 and Hannah 6. Real Water 3 and Hannah 6.
Real water three.
Thank
So
you.
you want to go to the other lawsuits, claimants and all that stuff.
And it's also Costco 16. Those are all the same. And then real water 4.
So if I, Your Honor, if I could first, just so you're aware, the court's camera is not on, so I'm flying blind here, so I apologize if I'm interrupting someone. I believe the Hannah motion we're discussing is the companion or would be companion to Real Water 4.
Real water 4. Real water 3 seems to be kind of the same title. It is.
Real Water 3 is also very similar. Real Water 4, I'm sorry, is about the Hunwartson and Gallagher verdicts in particular, and Real Water 3 is a little bit broader than that. It's about the other complaints made by other pending plaintiffs.
Yeah, so I think three matches up with Hannah's 6.
Sure. I'm ready to argue however Your Honor wants.
Okay. So I'm inclined to at least grant in part, in my notes says see plaintiff's opposition, page 16. Oh, so Blaine Jones, I already ruled specifically on that. The verdicts looks like plaintiffs don't oppose reference to the verdicts, but do, oppose potentially mentioning kind of along that pre-admission issue, which can be handled during trial. Inclusion other claims, vague. So yeah, verdicts, judgments, settlements, probably out, lawsuits probably out, but in terms of claims and instances and facts, probably deny the request to exclude those, but welcome arguments.
Go first, or if you want real water to go first.
Doesn't matter to me.
Matt, your choice.
You know what? Why don't I go first, just so I'm not treading over everyone else, because I am really thrown off by the fact that I can't see the court, and I apologize that it's a
happened
personal
before too.
Your Honor, we don't have to belabor this one.
Oh,
We've agreed to quite a bit. If you look at our opposition, we did a kind of omnibus opposition to this one. We conceded that we weren't going to discuss the Gallagher trial results or the Hunwartson trial results.
yeah, that's what I said.
I think the court's.
Well, it's his motion. Let him talk first. You could oppose.
Yeah.
So, Your Honor, I actually pretty much agree with the court and with what Mr. Parker said. I just briefly want to clarify something as regards to other lawsuits. So there were prior lawsuits not related to this case that I think everyone agrees are irrelevant. But there are, for example, Mr. Watkins has come up today. Mr. Watkins has a lawsuit against Real Water. Or, for example, Lisa King, who came up during the motion to reconsider. I guess I just want clarification. I don't want allegations being used as evidence here. Like, for example, like that, and I know it's not relevant anymore, but for example, that Lisa King has autoimmune hepatitis. Obviously it's more complicated than that. and the case hasn't gone through expert discovery, and I just don't think it's proper for allegations to be used as evidence. And that's basically all I wanted to say on this motion.
Thank you. Mr. Fierce, anything to add?
I won't go against your earlier desire to grant part of it, but when we go to the claims and I join with Mr. Kaufmann. One of the reasons they talk about these claims, we need to bring them in is to show notice of defect, which again, as we said, we don't have those notices in Milwaukee, but the second reason is to causation, which at least, you know, there is a defect in that causation, which again, is not going to be relevant, and you have the hearsay element of those things. So we would say that also the claims, I think they have enough with the 8 plaintiffs here to show this, whatever they want to do, common exposure, whatever kind of theory they want to do on causation and defect, to the extent that they even need to do that, giving a prior ruling, it's going to be unduly prejudicial, and we should just stick with the claimants that are in this case.
Thank you.
No, I was trying to say earlier that we may not have anything to really argue about. I think I understood where the court was going. Certainly, Mr. Watkins, Ms. King, they've had their own issues with this. If this is very similar to me in terms of Mr. Jones, he has his own issue. And if they want to try to show some type of bias or motive, if they were called as witnesses, they can do that. But certainly a common experience based upon their consumption of real water is relevant. And to the extent they had noticed, prior and subsequent incidents can be used based upon the case law we've cited already. So I think the court's correct. We don't mention the lawsuits in terms of Gallagher and Watson, but these individual claimants and their problems and how they're similar to ours and how they could have presented information in terms of notice, that all should come in. Thank you.
Thank you. Any rebuttals?
Just very briefly, Your Honor, Matthew Kaufmann for Real Water again. I think in plaintiffs, Your Honor said it best, I think yesterday, and plaintiffs already made a reference to this today too, that this case is not a motor vehicle with an accident with a broken arm. This involves internal injuries. And I think and maybe I'm mistaken, but part of what I was hearing from Mr. Parker is they want to, once again, skip the expert step and have the plaintiffs, for example, Mr. Watkins, testify that real water caused his issues when that has not been proven yet. And that's the only issue I would like to raise on rebuttal. Thank you, Your Honor.
Thank you.
We join in that, and then kind of go further. There is no notice to us, Milwaukee. So if you are inclined to deny this motion as to notice, decline it as to real water, but still grant it as to Milwaukee, and we would ask that you give a limiting instruction if that's your inclination, because it's not notice to us.
Thank you very much. So I'm going to grant part, deny in part the motion to a certain extent. It's unopposed. And so granted to exclude testimony and or reference to other lawsuits, other settlements, other judgments, other legal claims, which would probably be encompassed in lawsuits, I would imagine. But denied in part without prejudice to other, what I would characterize as facts, layperson testimony. Those are better handled on a question by question basis, and there is relevance at the very least as to notice to real water. Any issues, as Milwaukee mentions, issues where these types of things likely do not give any notice to Milwaukee. Milwaukee can certainly propose jury instruction or instructions. I'm happy to consider those at the time I have proposed jury instruction. And that's let's see, Real Waters 3. What was the other one?
Four, Your Honor, and I think Hannah 6.
Hannah's 6 certainly, and 4 was
It said.
oh yeah, the 2 other trials, right?
That's correct.
Yeah, sorry, Your Honor, Matthew. 4 was specific to Hunt, Watson, and Gallagher, so I believe we have an agreement on 4 based on the ruling on 3.
Yeah, so 4 is included in that as well. What would be next? Hannah 7.
I think I can shortcut this one too.
Okay.
At the Gallagher trial, we use the MMWR, which is the CDC's monthly morbidity weekly report. There's a little bit of a peak in 2018, and then there's a big peak in 2020. And so what we use that for is to argue that there was a peak in 2018, and we intended to do that in this case if Kaveh was in it, because she's the only 2018 case. But since Kaveh's not in it, we really don't need to go there with that argument. So I can agree not to argue that there's a 2018
Peak or a spike.
a spike, whatever they want to call peak or spike. So if that, if that's agreeable, that solves the matter. I think there's 4 or 5 motions on this. Yeah.
There's many. Anybody?
Your Honor, if they're just gonna stick to the actual document and what it does purport, and where there is an association
In
found
2020.
period 2020. We're not gonna object to anything. I think our concern was more of every time it goes up, there's this peak and all these kind of things. I think it's.
So yeah, plaintiffs have agreed to limit to that 2020 peak or spike, which I think almost everyone agrees that that's actually what happened. Anybody have anything else to add? Or?
Joel Odou for Real Water, Your Honor. Just to add that, we'll prepare an order for affinity motion number 2, which is pretty much the same thing. I'll say exactly what the court just said.
So why don't you do it for all of them then? That are,
2 or 3 other ones.
yeah, there were a lot. I mean, at least I thought they were.
It's Joel, it's Real Water 2, Costco 3, Hannah 7.
Costco don't include that one because it's
Okay.
Hannah 7.
Hannah 7,
Okay, Real Water 2 and Hannah 7.
that's correct.
okay. Thank you all. Okay. Real Water 1, maybe?
Sure, that one was unopposed, Sean.
Yeah, so I have no opposition, therefore grant. This is Real Water number 1, preclude admissibility of consent decree. That one's granted, unopposed. Oh, is that in another thing? Of course. Real Water 9.
That would be me, Your Honor.
Okay, let's see. So this one is Real Water's motion limiting number 9 to preclude customer complaints and evidence predating complaint. I think it's probably that same ruling that I already gave on plaintiffs in terms of I'm not inclined to blanket exclude, and I think to be maybe reiterate, I think a lot of this may go to notice and punitive damages issues, but so I'm inclined to deny, but welcome arguments.
I understand the court's position, and given the rulings and, the court's already ordered for us to have a meet and confer on customer complaints that our touchstone in this. I'm not going to belabor the point. I just want to make sure we're not precluded from raising objections to these exhibits or this evidence during the course of trial. That's all.
Yeah, thank you very much. Any opposition, or are you okay?
No, Your Honor, we understood.
Yeah,
Thank
so denied without prejudice, and without prejudice certainly means that, especially on ones like this. So yeah, engage in your good faith meet, confer, go over particular issues relating to the evidence and documents previously set forth in plaintiff's mirror motion to this. And yeah, if there's disagreements, I can rule on them calendar call and or question by question basis. So denied without prejudice. Next, Tim, okay.
Your Honor, Matthew Kaufmann again. I believe 10 is kind of a partner motion to 9, and I believe that also fall underneath your prior
Same,
ruling.
Yeah, same ruling on 10.
Okay, that's acceptable to real water.
17, do you have a 17?
We do.
Yeah, that's Babcock again related. I don't know if you want to defer it with the other one.
Is that what I did on the other one?
Yeah,
Okay.
it's just another issue. It's to preclude Babcock for another reason. In fact, I think we deferred, plaintiffs have 125 that came up yesterday, and I believe we deferred that too, so it probably makes sense to lump them all together.
The 17 calendar call deferred. Any more real water ones?
Just on that one, I think there's a couple, it's mostly the expert one. Just deferring, some yesterday were like, we'll pull them down. We didn't necessarily agree it might not be moved because the potential, the punitive damages, but I agree with deferring especially Babcock ones. I think there's one or two others from yesterday and some call, and just allow us to analyze what, if any, these witnesses testify as to elements of the,
So you have to be, so that I know and the other side knows more specifically, do you have particular ones you're referencing, or?
I thought you had the real water, that you had the two Babcocks. Then I think we had Kenner, then we had Full. That we deferred.
Your Honor, I have 2 of them, and it's plaintiff MIL 25 was moved to Thursday, which tomorrow. And then plaintiff MIL 26 was also moved until tomorrow. Those are the number designated. 25 definitely dealt with Babcock.
Okay, so Babcock, and then I think 26 is Hull. And then number 7 is Kemp. And those were at least moved to tomorrow.
That's correct.
Yeah, and I did, to be clear, I said at least until Thursday, if not later, if that doesn't give you time enough, which strong possibility. So I'm not saying we're going to necessarily do them tomorrow, but so what do you all think would be next up for me?
Yeah, Judge, I have.
Well, let's.
5.
Yeah, we have some real water MILs.
Oh, good.
That'd be a good idea.
Let's
Just
keep going if we can.
go in number.
Yeah.
And we don't miss anything.
Yeah.
Your Honor, we've heard the court's ruling, but MIL 5 is to preclude lay witnesses from providing medical opinions.
Oh, hold on one second. Let me get that from me too. Yeah, I kind of like this. So this one. So you're talking about real water number 5, right?
Yes, Your Honor.
Okay, go ahead.
Mr. Kaufmann is going to present. I don't want to step on his thunder, but we've kind of heard.
I'm here. Sorry.
Go ahead, Matt.
All right, I'm sorry, 1 second. Let me pull up my notes, Your Honor. So First, do you have an inclination on Real Water 5?
So I'm inclined to deny without prejudice, too broad, too vague, better handle question by question, answer by answer basis.
If I could, Your Honor, then let me specifically address a couple of examples of the testimony we expect to see and our specific objections to it. For example, you've already heard discussion today about Mr. Watkins and about Mr. Watkins Mr. Watkins drawing his own opinions between after being told to stop drinking alkaline water, that real water causes liver injuries. And once again, Mr. Watkins has a slightly complicated medical history that I'm not going to get into because it's not really relevant, but there are potential other causes for his liver problem other than real water. And I think, for him to just say, well, real water did this is skipping a step and basically usurping the role of the expert. Similar, you have plaintiff took the deposition of a woman by the name of Lois Kessler. Lois Kessler opined that her and her parents went out, her parents were in town, they had lunch somewhere, they went out to eat, and they all got sick. And of course, it was real water. There's no evidence, none of them sought medical treatment, but she, in her opinion, it was real water. And once again, plaintiff is just trying to have Ms. Kessler step in the shoes of an expert when there is no testimony. And, Mr. Odou touched on Mr. Fisher, who I believe he drank like 2 gallons of water over the course of 3 hours and then got sick. So once again, and I understand what Your Honor is saying about notice to real water, but that doesn't mean that every issue that occurred with real water is necessarily related to hydrazine as well. And I think that also needs to be taken into consideration. And we just ask that the court make the parties abide by the NRS as far as lay testimony goes. Thank you, Your Honor.
Thank you. Any opposition?
Your Honor, I think the court's inclination is correct. This is something we've really already dealt with, Your Honor. Can you hear me from here, Your Honor?
Yeah, no, you're fine.
Okay, thank you, Your Honor. The court has already addressed this, I believe, in terms of these customer complaints. And so I think this is a rehash and really another attempt to address it again. I think this, based upon what the court has said, we're going to meet and confirm these customer complaints, and then the court will decide when these witnesses or these customer complaints are brought before witnesses during trial. So I think that's what the court was inclined to do, and I think that's the appropriate way of handling it.
Thank you. Any rebuttals?
No, Your Honor.
So I'm gonna stick on this one. Initial inclination again, denials without prejudice, and definitely this issue to be included in your meeting confer prior to the continued calendar call. But denied without prejudice, too broad, too vague, better handle question by question, answer by answer, exhibit by exhibit basis, at least at this time. But definitely include these because it's essentially the same issue I've already told you to meet and confer about in terms of the documents and that. So no. Okay, what other real water ones do we have?
6 also.
Oh. So real water numbers. Oh yeah. I'm guessing nobody will be surprised by my inclination on this one. Inclined to deny real water number 6 to preclude plaintiffs from referring to hydrazine as rocket fuel. Go through all sorts of reasons, but they're articulating in great detail in the opposition. But welcome arguments.
Nothing further to add, Your Honor.
Yeah. So number 6 denied. And to be clear, this is the type of denial that I expect that plaintiffs will refer to hydrazine as rocket fuel because there's a bunch of evidence that says that's what it is. Okay. Next, you have 7?
7.
Okay. 7. Preclude pathology reports and results from non-plaintiffs. It's kind of similar to those other issues we've been talking about in terms of the, the non-plaintiff complaints, etc. So inclined to deny without prejudice, certainly welcome. If Real Water or any other defendant wants to offer some type of limiting instruction, I'd certainly consider that. But I think, opposition articulates pretty well why I'm inclined to deny it without prejudice, but welcome arguments on this one.
Yes, Your Honor, Matthew Kaufmann for Real Water. Just very briefly, I think one issue that kind of gets lost in the shuffle and plaintiff's opposition is the fact that if you look at Dr. Datnow's expert reports, there's no evidence. He never said he looked at the Burke paper, the Burke article, and when coming to the opinions in this case. And I think that, saying that this opinion, he should be allowed to testify about the Burke people because it informs his opinion. In this case, is not supported by the documents, and on that basis, I think his testimony should be limited to the minor Severin in this case. Thank you.
Thank you.
Yeah, Your Honor, the Burke article is one of the things on Dr. Dadnow's review list. True, it wasn't discussed a lot in his deposition because his deposition in the Gallagher case took 18 minutes. And the deposition in the next case on Wardson didn't really focus on this. But this is one of his items reviewed. And this is what, as I said in the opposition, we want him to focus on. Because if you take a look at the Burke article, the top right there, basically what the court's seeing there's 6 different slides there. There's 3 on top, 3 on the bottom. The top right and the bottom right, if you see the blue, kind of like Blue River or something, that is bridging fibrosis. And that's what the article describes it as. So all Dr. Dadnow is going to say, and what he has said is these people have bridging fibrosis, and Burke attributes it to drinking real water. And by the way, you shouldn't have bridging fibrosis at the age of these senior plaintiffs. And we know exactly who all these people are, Your Honor. We provided defendants a key for each one of the persons in the Burke article. The Burke article doesn't use names. It calls patient, I can't remember if it's 1, 2, 3, 4, 8. We have provided a key though, because we know who all of these people are plaintiffs. We represent 3 of them, and another firm represents 1 of them. So we know exactly who these people are. And so all he wants to do is, like we say on page 6 of the motion, he's comparing. First, he's going to explain the Morales slide, what that depicts, which is bridging fibrosis, which for an infant is unbelievably unusual, Your Honor. And then he's going to compare it to the Burke slide, and that's pretty much his whole testimony.
Thank you. Any rebuttal?
No, if that's all he's going to testify to, I'm okay with that.
Okay. So stick with my initial inclination, which was deny without prejudice. We need a limiting instruction. Happy to consider that. And plaintiffs have offered the roadmap to what their plan is to have what was it?
He's a pathologist, Your Honor. His name is Datnow, Datnow.
Okay, yeah. So, okay, there you go. Do we have 8 next? Or?
Yeah, I'd also point out Dr. Hudson,
Dr. Hudson, the
hepatologist, also uses this Burke article.
Okay.
Yes.
Yeah, so again, denied without prejudice, as I stated.
This motion is not about the Burke article, so it's fine, Your Honor.
Okay. 8.
Your Honor, real water motion limiting number 8 is about Jeffrey Dosatel and Patricia Converse. I don't know if that's become moot since they worked at Real Water, and 2016, 17, and 15.
No, Your Honor, it's not moved because it goes to the punitive damages case.
Okay, so, Real Waters, motion limiting number 8, limit lay testimony. Inclined to deny, too vague, too overbroad, better handle question by question, answer by answer basis. Welcome arguments.
Thank you, Your Honor. Joel Odou on behalf of Real Water. Mr. Dosatel worked at Real Water in 2016 and 2017. The plaintiffs intend to ask him a series of hypothetical questions about if he was in charge, would he have stopped the production line and done different investigations of complaints? It's completely improper because that wasn't his job. He was on the manufacturing line. And for him to speculate as to what he would have done in regards to complaints that he never saw until his deposition are improper. In addition, Mr. Dosatel was given leading questions that led him to believe that Real Water caused his daughter's gallbladder injury, and he intends to offer a lay opinion that the gallbladder was taken out because she consumed Real Water. We objected to it in the Gallagher case and the Hunterson case. One time it came in, the other time it didn't come in, just for the court's information. Patricia Converse was initially a receptionist at Real Water. She made friends with Amy Jones, who was one of the owners of Real Water. She eventually got promoted. Again, they had a falling out over some religious differences, and Miss Converse, again, was shown complaints that she didn't see before and wants to offer speculative opinions about them. And so we think that those types of questions are fairly off limits, and it's fairly specific as to what we're trying to exclude. Because we've seen this in 2 prior trials. So we targeted this motion in particular as to Mr. Dosatel and Mr. Converse, who have no firsthand knowledge of what occurred at Real Water in 2020 or 2019 or even 2018 to some degree. So we think that their prior testimony would be improper if offered in this case.
Thank you very much. Oh, go ahead. He wants to go to. No, go. No need for you to.
Just gonna get close to this microphone just briefly, to the extent plaintiffs articulate that this is somehow relevant to notice, I just want to reiterate, this is not relevant to notice for Milwaukee. So
thank you.
This evidence is relevant to the Collins and the punitive case specifically. Let's start with Converse because that's in time. She was there first. So they hired Patty Converse to be the receptionist. She was the receptionist for 5 years.
The one who got promoted, right?
She got promoted to be the quality assurance director. Didn't know anything about quality assurance, admitted that in her deposition. And she was in charge of HACCP, which is a very important procedure to make sure the plants were being run in appropriate fashion. So they didn't have a procedure to document the customer complaints. And she said that, Dosatel said that, everybody has said it. No procedure whatsoever. Instead of investigating the complaints, they gave the complaints to the sales staff and sent them 3 bottles of or jugs of Real Water. That was the complaint investigation procedure. So our expert, Dr. Hudd, is going to testify that that is not an appropriate customer complaint investigation procedure, and that's one of the prongs for the punitive claim. The other prong is they didn't have appropriate HACCP procedures. And again, Miss Converse was a receptionist. She wasn't trained in HACCP. She admits point blank that she didn't know anything about HACCP. With regards to Mr. Dosatel, Mr. Odou refers to him as the production manager. There's actually a business card that says he's the quality assurance director. They never told him he was the quality assurance director, but they made business cards for some reason and called him the quality assurance director. But in any event, as production manager, he testified that if he had known about any of these customer complaints, which again, they didn't give to anybody except the salespeople, he would have stopped the production line down and done an investigation. And we think that's appropriate testimony that he could submit.
Tell me about the daughter gallbladder.
Yeah, I'm gonna agree not to go into there with the daughter, and also Mr. Odou didn't bring it up that like a number of people, both of his, at least one of his dogs were killed from drinking Real Water. I'm not gonna bring that up for Mr. Dosatel. I'll leave that out. So I don't mind being excluded on both the daughter and the dogs.
Okay.
Although I would point out something about the health district report has an express section in it about people's dogs being injured by drinking real water. And that's pretty much it, Your Honor. We don't think they should be precluded from testifying with regards to anything that has to do with the operation of real water or their lack of training,
Thank
or
you.
especially with the customer complaint procedure.
Sure. Any rebuttals?
Yes, Your Honor, just very briefly, go ahead and we appreciate the plaintiff is not going to bring up the dog. The plaintiff just did bring up the dog, and for the court's information, one of the dogs fell into a swimming pool and drowned. So yes, the daughter died from water, but not from drinking real water. The other dog that died was either 14 or 17 years old when the dog passed. And so for him to speculate that real water killed his dog, he gets very upset, as most people do when they talk about your pets or your children who are injured. Mr. Destito gets very upset when talking about the daughter or the dog. And that's why it's also prejudicial, because it really.
Plaintiffs acknowledging, and I'm gonna order that's excluded.
Thank you, Your Honor.
Yeah.
As far as Mr. Destito being in charge of quality assurance, again, he ran the line. He ran the line that filled the bottles of water. He was in charge of the quality for the line, not for customer complaints. And certainly that goes to weight. We can argue that when his testimony comes up.
You read my mind because I have written here, wait.
Yes, Your Honor. And we will address that if he is called again. He's very eager to testify. He's very angry about real water killing his dogs and injuring his daughter. So I'm sure he will be here in person. As far as Patricia Converse goes, again, she had a falling out. We're going to probably hear about that as well. And so I anticipate that the court may grant in part, deny in part, or we just may take this up later. But at least the court now has a preview of what we're going to hear. So we thank you for the.
No, thank you. So grant in part, denied in part. So grant in part to exclude Mr. Desitel from testifying about his daughter's gallbladder, and to exclude him from testifying about his dog or dogs, plural, blanket exclusion there. And whoever ends up calling him, instructed to tell him, hey, this is our case, we're calling you, judge has already told us you can't testify about to your daughter's gallbladder or your dogs, and
We gave Mr. Desitel a no list too.
Okay.
Basically, the way that works is I do up a handwritten no list. I show it to Mr. Odou and Mr. Kaufmann, and they say, add this, you forgot that, and we show it to the witness, and no.
Okay.
We have a couple of those, Your Honor.
Yeah, sounds good. And so those are excluded. The remainder denied without prejudice. A lot of the issues go to weight, go to impeachment, cross, better handled by question, answer by answer basis. Okay. What do you have next?
So real water motion limiting number 11.
11. Oh, so real water's motion limiting number 11 to preclude reference, evidence, or argument regarding discovery and pretrial motions. I am inclined to grant this, although I have a question. Some of it, may be relevant, maybe. I do get antsy, nervous, anxious, however you want to say it, when parties like to bring up discovery disputes in front of a jury. I think that's almost never appropriate, but so I'm inclined to grant, but certainly welcome arguments.
Okay, well, I'll be brief based on your inclination. It mainly goes to closing arguments where they had a slide with a timeline that just showed the length of discovery, how many depositions, how many, pretrial motions, how long this went on before Real Water agreed to admit liability and causation. There's no grounds for this. All it does is try to act like Real Water was making some nefarious efforts to try to drag plaintiffs through this and make it longer than it should have been. And that is just definitely irrelevant and highly prejudicial.
Thank
Your Honor, you're correct. We don't intend to argue discovery disputes before the jury. That's not what we intend to do. The issue that we have is that relatively effectively, I will say, Mr. Odou has argued or suggested to the jury that in its benevolence, Real Water has accepted responsibility for all of these plaintiffs. And so the jury's led to believe.
Open the door type of argument.
Bingo. And so when that happens, and they do it during voir dire, they do it in opening. And then once they did it, Your Honor, I created the chart because quite often I'm on this side of the table more than I am on this side of the courtroom. I had a chart created showing all the work it took before they actually agreed to accept responsibility. Because as the court knows, this case was filed in 21, and it wasn't in the Gallagher case. They didn't decide until days before trial to accept responsibility. So the plaintiffs went through depositions, which is not very easy for people who are not in our line of work. Mothers, fathers, and I don't want the impression to be that from day one, they accepted responsibility. So if they get up and argue that from day one, 2021, that they accepted responsibility, we should show what it took for them finally to accept responsibility. The 121 depositions, the 35 experts, those sorts of things before even after their own expert, Dr. Goldsmith said, hydrazine caused this problem. Hydrazine shouldn't be in water. They still didn't accept responsibility. It took a month or 5 weeks worth of pretrial motions for summary judgments, motions in limine. Finally, Real Water accepted responsibility and conceded liability for those plaintiffs. And Your Honor, it wasn't until recent that Real Water accepted responsibility for these plaintiffs. It wasn't in 2021, 22, 23. It wasn't until this year, less than probably 6 weeks ago, that they accepted responsibility. So if they open that door, Your Honor, I think we should have the right to inform the jury of what the truth is.
Thank you very much.
Thank you, Your Honor.
Any rebuttal?
Yes, just briefly, Your Honor, it's the way they present it. It suggests that Real Water doesn't have any right to conduct discovery and to take these depositions to gather all the information in order to make these decisions. In this case, Real Water stipulated to liability and causation as far as the remaining plaintiffs in here before the pretrial motion filings. And so to make some argument that, to suggest that they drag this out because they don't have a right to have discovery and just, drag it out. Bless you.
Well, let me ask you, so I mean, the open the door argument, in fact, I may have had a trial or two where that was raised. Like if you all come in here, Mr. Parker used the word benevolence or something like that, and hey, we're not so bad, we agree, we stipulated, etc. How does that not open the door for them to show this timeline?
I guess it's really, it comes down to how it's presented. If it's presented as, how dare they, can you believe what they force these plaintiffs through? And suggest that, the minute they were met with the complaint, they should have just rolled over and said, oh, okay, we admit liability, let's wrap this up and shut it down. It's really how it's presented. So I mean, while opening the door, I guess if they think, okay, well, you apologize, you tell the jury that you are admitting liability, then we could say, but they didn't do it until, 2 months ago or whatever. That's a different way than just going, here, look at this. They made all these plaintiffs sit for their depositions. They took all these doctors' depositions. They got experts and, to suggest that, hey, this has been over a year-long process because they're bad actors. That's inappropriate. And that's where the prejudice really comes in.
Thank you. So here's where I'm torn a bit in terms of, sometimes on these, it's hard to draw this fine line of, hey, it's okay for you to say X, but not Y. If you say X, you're okay, but if you say Y, then you're not. And it's certainly, even in rebuttal, it's, hey, yeah, okay, we kind of understand the open the door argument, but plaintiffs can't go too far. I don't know that I can draw a line in terms of, hey, plaintiff, you're limited to this sentence or that sentence. And I also would note there's, punitive damages issue that certainly Real Water's not stipulating to that. So these are, well, I'm gonna change my mind. Deny without prejudice, certainly welcome, approach, etc. You think they've gone too far, or think they are going too far, object. And I'll handle it at the time, so denied without prejudice for those reasons. It was 13 next.
12, Your Honor.
Oh, yeah.
Your Honor, can we take a 2-minute break?
Yeah, well, let's take more than 2 minutes. Come back at 3:20.
Thank you, Your Honor.
Thank you.
I got you.
Resolution.
Yeah, got you. We can defer. Okay.
Yeah, so I wouldn't defer all this if I thought.
Got you.
And I think some of, like, number 5, it's gonna come to head with depot designations unless you get told.
Yeah,
Individuals live, we can deal with that.
yeah, I think 1 through 5 we could defer.
So the court's muted.
And then number 5 is the okay, so number 4 is the lay testimony about Patricia and that we can defer. And then number 5 is unrelated ORP meetings. And do you want to, I can argue that, or we can?
No, I think that relates to the issue you and I were talking about earlier.
Okay. Yep.
So we'll defer on all those.
Yep.
Is that it?
Yes. Okay. One stop.
That was easy.
So
Yeah.
There's Milwaukee.
you just have to let me know which ones you want me to hear.
Milwaukee. 2, the Maine and Romania one.
Okay. Okay, so so Milwaukee Motion limiting number 2 to exclude reference to the phrase made in Romania or other reference to foreign entities involved in the manufacture. Trying to, well, I had a question, so I mean, they did give me a picture, right, that says made in Romania or something like that, so it's kind of hard to exclude, but welcome arguments, because yeah, don't want to go overboard, but might be a fine line.
Fair enough, Your Honor. And I think that, as you've heard me say before today, and you'll probably hear me say a couple more times, yesterday's ruling, I think, changes the context here a little bit. The thrust of our motion is a question of foundation. There's no foundation. A lot of their arguments and their opposition are about, the cost of production or the cost to, the year that the tip card or the instructions were made. But the location of the manufacturer has nothing to do with that. There's no evidence to suggest, or no evidence in the record, or that they've presented that the cost in Romania was cheaper than the cost in the United States or otherwise. And so the use of those phrases, right, that we're creating shortcuts because we wanted to make them in Romania or similar arguments by counsel are inappropriate because they lack foundation and they seek only to inflame the jury. Again, we're at a place where this simply isn't relevant to punitive damages, where the tip card or not the tip card, but where the meter is made. And so, the question of cutting corners in production of the meter, there's simply no evidence of that. So that's the thrust of the motion there.
Oh, thank you. Any opposition?
Yeah, Judge, the meter actually says made in Romania right on it. I mean, I don't know how we get around that. Number one. Number two, there is testimony from the plant manager, Adrian Petrine, Petrean. And
Is that the one moving from Portugal, or is that a different one?
that's the third issue.
Okay.
But Petrine is the one who says that they moved from Portugal to Romania to save money, which is pretty common for European manufacturers to do. So I think there is some relevance there. So I don't know how we show the jury the meter that says made in Romania and the box stamped made in Romania. It's kind of interesting because in the Gallagher case, I agreed not to harp on the fact that the titanium tubes were made in Russia. I said, well, I'll just say they're made in Eastern Europe. And as soon as I said that, the Milwaukee attorney got all bent out of shape because I was implying they were made in Romania. So we are not harping on the fact they're made in Romania. I mean, the only way we come in is if we play that portion of the Petreon testimony that they moved the plant for cost. And, frankly, right, I don't think we've really focused on that in terms of the punitive damages case. I think the punitive damages case is really focused on the fact that they had two different warning labels, one that they gave that disclosed the risk, and the other one they didn't, or the same kind of warning they didn't give for this product. They had that on another label. That's really the foundation of our punitive damages case. So I think, if the court's inclined to do anything, I think maybe we should be admonished not to overly emphasize that it's made in Romania. Not to jump up and down and say Romanians are bad, something like that.
Thank you. Any rebuttal?
I'll be brief. The question of manufacturer is not relevant here for a couple of reasons. The first of which is Milwaukee is a seller of this product. So that's important. Second is the question is all of the questions about where it's located or if it's cutting corners in the cost of production or the manual is drafted originally 35 years ago. I don't, obviously the meter says what it says, but our concern more is the same arguments going up that we're cutting corners or that, the tip card, for example, was not created outside of the United States. So the concern is, one, Milwaukee is a seller, right? Not a manufacturer of these things. So cutting corners in cost of production, especially in light of the causation or the liability ruling, it simply is not relevant anymore or ever and is unduly prejudicial.
Thank you. So grant part denied in part, grant part to exclude any reference or argument that the manufacturing plant was moved from Portugal or wherever else to Romania to cut costs or to cut corners. That's excluded for reasons articulated. Remainder denied without prejudice, as I remember correctly, the meter does actually say words effect made in Romania, and I think there might be something else as well that's on there. To be clear, plaintiffs admonished not to overly emphasize that, but not exclude that fact from the case. So denied as to the remainder, but granted as to what I said. What one do you want me to do next?
Let's do three.
Three?
I'm not sure that, I think we might need to look at one again, just to see.
Sure.
So we'll go with three and then.
Bear with me a second. Oh, yeah. So Milwaukee's number 3 to exclude comments or argument that Real Water purchased more than 100 ORP meters from Milwaukee because they were malfunctioning, or the Blaine Jones 2013 video is made for Real Water production train. Applying to deny, I think there's sufficient evidence to make such implications or arguments, goes more to weight than a blanket exclusion. But welcome arguments.
Your Honor, the critical framing issue here is that there are several separate Real Water entities. The testimony that we've cited in the motion is that Real Water had created this marketing plan where they were creating a separate business and they were going to purchase meters for those people to use to show people other things. Blaine Jones, the video that we're referencing here, that was created for that purpose. Our concern is the conflating of the issues to the jury that they were purchased. We have testimony that we were purchasing, this lot or these by the hundreds, not so that we could give them to our salespeople, not so that they could, not because they were malfunctioning during the process of Real Water. And I think that's particularly important when it comes to where we're at now, where it can't go to notice because if the testimony so far is that they're purchasing them not because they're malfunctioning, but they're purchasing this lot of them for a separate purpose, that doesn't put Milwaukee, the fact that they're purchasing those for a different company doesn't put Milwaukee on notice of any issue. So I think that the critical framing is the separate companies, and that the inference that they were purchasing these every single meter for the purpose of production is improper.
Thank you.
Your Honor, do you need further argument? I think your course inclination is correct. We had a chart of how many of these they were purchasing, the problems they were having. We have emails between Jason Brown and Milwaukee because of problems trying to figure out how to make these things work.
So do you want me to answer your question?
Okay, I got going.
Well, that's
Kemp stole the last one from me.
You're far from the only attorney who asks a question, doesn't wait. And I do speak very slowly, so that's understandable sometimes. So to answer your question, the answer is no.
Okay, thank you.
Yeah, so like I said, I've reviewed this amongst all the other ones. Very detailed opposition here. There's sufficient evidence to support, arguments, characterizations, implications, and it goes to wait for the jury to consider. The concern that the jury will conflate issues as stated, I think is a legitimate concern, but overstated. I have a lot of faith in maybe confidence, better legal word, confidence in juries, to make correct decisions and weigh evidence appropriately. And so denied for those reasons. Which one next?
I think that it's probably best if we defer, our Milwaukee's number one,
Okay,
just so.
sure. Did you have more after that or? we all done?
That's,
Okay,
yeah, we had the, sorry.
that's okay.
Just the Sands one, but I think that goes with all.
That
the
will
rest of
go
the Sands
into,
ones as well.
okay, so we'll defer, do you have any others for today?
No, that's all for us.
Okay. Anybody else have any other motions before we play videos?
Your Honor, just for clarification, could we go over what the plan is for tomorrow? I know there's the good faith motion, and I suspect it's Dr. Sands. Our motion to eliminate 18 and another motion to exclude him, and then the MSJ. But I wanted to see what the calendar is.
Man, that's, you all tell me if, why don't we do this, let's take another break, you all meet and confer. And figure out what you all want me to hear is totally fine by me.
Right.
Thank you.
And then, let's come back at 4.
Robert, before the break, can I ask, we filed the supplemental briefs related to the Sands by last night. Are those, has your honor had a chance to review those, or
Yeah.
Is that something we could?
Good question. Oh, yeah. So, yeah, these are these two. Yeah.
The other two.
Uh-huh. So the answer is yes, I did review these. Yeah, thank you for asking. So come back in 10 minutes or so.
From 15 is now back in session.
Okay, so what's on for tomorrow?
As we have real water motion eliminate number 18 pertaining to Dr. Sands. Real water motion summary judgment pertaining to Dr. Sands. Milwaukee motion eliminate number 4 pertaining to Dr. Sands. And then we have plaintiffs motion eliminate 7 and number 23 pertaining to Dr. 10. I think that's it.
And the good faith motion.
Oh, yeah, thank you. Okay, so you get them all. Thanks. All right, so video. Oh, so like the first half or doesn't
Yeah,
it?
the 10 seconds is in the 20 seconds.
Okay, yeah, that's.
Okay, the old one now. Okay.
Now is the 22nd one.
Yeah, it's the 22nd one.
Anything further in opposition? And
No, Your
feel
Honor.
free to regurgitate or remind me what you already said. That'd be
Just
good.
prejudicial, always probative.
Any response?
Well, Your Honor, this is Lyric, which is one of the plaintiffs, and in addition to the fact that we would like to show this during the opening, that's why we're asking it to be pre-admitted. The entire video is actually part of Dr. Guthrie? Guthrie's deposition. Dr. Guthrie was the treating physician for all 5 of the babies up there in Utah. And so during his deposition, this whole video, the 2.5 minutes is shown to him and he comments upon it and on and on and on. So I don't see why there's any prejudice of us showing the 22nd during. And you know, it's not like the plaintiff is bleeding or they're cutting an arm off or something, you know, it just shows the typical state that these acute liver failure victims are. They're unresponsive.
Thank you. So, motion to pre-admit the 22nd version now of, which one's this?
It's video 3.
3.1,
3.1.
the 22nd pre-admitted, granted, it certainly, goes to that rule, a lot of the evidence the plaintiff seeks to admit is certainly prejudicial. That's not the rule though. Whether it's substantially outweighed, it's not, and it's certainly relevant, certainly probative. And reduced from the extended version to the 22nd version, so that is pre-admitted as well. So we were set to begin tomorrow at 10. If you all are okay, I could do 10, but I have a 9 o'clock calendar. It's not that long, but it might make more sense to start at 11, but
11's fine with us, Sean.
that works. Everybody okay with 11? Okay, see you tomorrow at 11. Thank you. Thank you.